Hello! In this video, we will talk about the Canadian justice system. The Ghomeshi case will be the underlying example that will be used in everything I'm going to explain. Basically, throughout the Ghomeshi case, people have been talking about our adversarial justice system, and that the adversarial justice system presumes innocence before guilt. Guilt must be proven. So that is what we generally assume among other hallmarks of the adversarial system. So, in case you're wondering, there are actually two justice systems that the Western world uses. Many countries use the adversarial system, and many countries use the other system, which is known as the Inquisitorial justice system. So the definition of adversarial system, the wholesale definition, is this. It is a justice system where the defendant is presumed innocent and both sides may present competing views of the evidence. It uses laws, rules, and procedures by opposing parties who contend against each other to try to obtain a result favorable to themselves. However, in 1954, the Supreme Court of Canada ruled in R versus Boucher, the role of prosecutor excludes any notion of winning or losing. An impartial judge or jury must be convinced of either of the adversary's perspective on the case presented. Precedents set in case law are primarily relied upon for decision-making and are binding. This justice system is generally followed by common law countries of the Western world. In criminal cases, this is often called the Accusatorial system, a method in which the accused is innocent until proven guilty and the burden of proof is on the prosecutor. The definition of the other justice system, known as the Inquisitorial system, is this. The Inquisitorial system is generally followed by civil law or Napoleonic law countries and is described as a system that aims to get to the truth of the matter through extensive investigation and examination of all evidence. The judge directs questioning in the investigation and the questioning of the witnesses. Victims have a formal role in the investigation and trial procedures. Civil code and statutes, rather than precedents, are primarily relied upon for decision-making. The presumption of innocence does not exist in this system. So again, the general assumption is that Canada uses an adversarial justice system. The general criticisms of each of the two basic types of justice systems are the following. In the adversarial system, the criticisms are that the inherent goal of winning a case trumps the search for truth. The system is more procedural than it is substantive. Lawyers are more apt to hide evidence regardless if it supports guilt or innocence. The more money the accused has, the better the attorney they can hire, thus more likely to win. For the inquisitorial system, the general criticisms are this. Too much judicial and prosecutorial power leads to corruption. The contradictory role of the judge to lead investigation and decide the verdict means they cannot be completely unprejudicial. It does not insist on the presumption of innocence until proven guilty. It limits the right to silence. It does not represent a democratic society. So, moving forward, I'm going to break down the hallmarks of the two different justice systems. The first hallmark of both justice systems is the investigation phase prior to the arrest. In the adversarial system, the responsibility for gathering evidence rests with the defense and the police. The police investigation is separate from the prosecutor powers. In other words, the prosecutor is not involved in the police investigation. However, in Canada, the police can consult with the Crown prosecutor during the investigation. That is a gray area, and I will leave that up to others to discuss. In the inquisitorial system, the judge and prosecutor are equally active in the investigation of evidence for the pursuit of truth. The judge can direct the prosecutor what to investigate. The prosecutor can also have judicial powers. The complainant or the victim has a formal role in this phase, including the right to line of questioning, and can be represented by their own lawyer. Now, as we know in Canada, we have a Victim's Bill of Rights system that has essentially turned the victim into a formal party to cases, particularly in sexual assault, domestic violence, for example. So, as we have seen in the Gomeshi case, the victim pretty much led the investigation. The victim told their story to the police and to the Crown and to their own lawyers as the victim preferred to tell the story. Nobody investigated, apparently, the victim's claims to test the credibility of their claims before turning this into a case. So that tells us that our investigation phase is not consistent with what the general description of the adversarial justice system is. It has the hallmark of the inquisitorial system as far as the complainant/victim having a role, a prominent role in the investigation phase. The next phase is the arrest phase. In the adversarial system, police can arrest based on probable cause, and a judge can order an arrest warrant at the request of the prosecutor. The accused has the immediate right to an attorney, even if appointed by the state, and a bail hearing within 24 hours or as soon as possible. At least in Canada, that is the time frame of which they are eligible. In Canada, the court can order a release on recognizance with little to no restrictions, or a bail with release to many restrictive conditions, a surety, and a monetary commitment in case those conditions are breached. Release on recognizance occurs less and less frequently, particularly in Canada. The accused is presumed innocent until proven guilty, and the accused has the explicit right to remain silent. The inquisitorial system works this way. A prosecutor or a judge can order police to make an arrest without obtaining an arrest warrant. The accused can be interrogated for an extensive period of time without an arrest warrant. This period of time can vary from country to country that uses this system. 48 hours might be a typical time period. The right to request a bail hearing does not exist. The prosecutor can decide whether or not to grant bail with various conditions, depending on the evidence gathered. The right to an attorney is not explicit and must be requested by the accused, and the prosecutor will decide. The presumption of innocence does not exist in the system, therefore the implied presumption is guilty until proven innocent. And in the system, remaining silent is considered to be a sign of guilt. So now let's look again at how the Canadian system works and in regards to these two systems and their inconsistencies. There really aren't a lot of inconsistencies, I don't believe. I would consider the arrest phase of our system to be more consistent with the adversarial system. However, with the way we handle bails and putting people in jail before they have trial, and in some cases, such as in cases of terrorism and immigration, people can be jailed without any charge. So the inquisitorial version of the arrest process and detention and bail has definitely crept in and overshadowed what the adversarial system is supposed to stand for, where the accused is presumed innocent. When we put people in jail who haven't been charged or tried, that generally gives the impression that they are guilty until proven innocent. So one can say, technically, we adhere to the adversarial system. However, theoretically, we are moving towards the inquisitorial system. Next, plea bargaining. In adversarial systems, the prosecutor is given unfettered discretion to negotiate a plea deal with the defense in order to dispose of the case before the trial, to obtain a conviction, and to reduce caseload. In the inquisitorial system, generally no plea bargaining exists in the system. However, some systems have adopted various forms of the practice within the last couple of decades or so. So we basically adhere to the adversarial system, which uses plea bargaining. And one can debate that the plea bargaining system is within itself a negative and flawed aspect of our system because it results in a lot of innocent people being convicted. Plea bargains happen for various reasons. The prosecutor has a lot of power to force plea bargains onto defendants. So it is not a shining aspect of the adversarial system. The next is the examination of evidence. In the adversarial system, typically there is no examination phase. So an independent evaluation of the evidence collected during the investigation is left to the trial. In the inquisitorial system, the examining phase is usually conducted in writing. An examining judge completes and reviews the written record and decides whether the case should proceed to trial. The examining judge plays an active role in the collection of evidence and interrogation of witnesses. In some inquisitorial systems, the legality principle dictates that prosecution must take place in all cases in which sufficient evidence exists. For example, the prosecutor or the judge has limited discretion as to whether or not charges will be brought. So let's examine how we handle the examination of evidence in Canada in our justice system before trial, after arrest, and before trial. So according to the adversarial system, there would be no examination phase. In Canada, we call this the preliminary inquiry. The preliminary inquiry is a hearing which functions much like a trial, except it is held for the purpose of, examining the evidence and determining if the case is fit for trial, if the evidence is sufficient for trial. Well, that sounds a lot like the inquisitorial system, doesn't it? So I would say that the Canadian system uses a blend here in the examination of evidence phase of the adversarial and the inquisitorial. And also here's a note. Canada has different levels of courts. Therefore, depending on the type of court or the type of crime, the type of the severity of the crime, the case can go to a different court. So it can go to a provincial court or a superior court, and basically it could also go to a administration level court, which would be held by a magistrate. So you could say essentially we have 3 different levels of courts. Generally, in the 2 lower levels, the administrative level and the provincial level, any crimes and offenses scheduled in those levels do not get preliminary inquiries. So in the 3rd level, the higher level, the superior court level, those get preliminary inquiries because those tend to be more severe crimes. They tend to, the prosecutors are asking for longer sentences. So that kind of what qualifies it for a superior court. It's a little confusing, but basically I'm just trying to illustrate the fact that we have different levels of courts. Therefore, each level may either adhere to the adversarial system or the inquisitorial system. And basically, our superior court level adheres to the something that looks a lot more like the inquisitorial level. And also, it has been illustrated in some cases that, including my husband's case, preliminary inquiry is an automatic step. It seems to follow that legality principle that the prosecution must take place in which sufficient evidence exists. So the question here is, what is the bar for determining sufficient evidence? That is the mystery in our Canadian justice system. People assume that bar is really high, and that the Crown must have concrete evidence. However, in cases of sexual assault, historical sexual assault, where there is no evidence, how is that proven that the case has a likelihood of conviction? We don't understand this. This is a gray area, another gray area in our system. Anyway, end point here to this slide is that depending on which level of courts we're discussing, it's either adversarial or inquisitorial. Therefore, the Canadian system is a mix. Now for the trial. The adversarial trial, the prosecutor, acting on behalf of the state, and the defense lawyer, acting on behalf of the accused, offer their version of events and argue their case before an impartial adjudicator, a judge, and/or a jury. Each witness gives their evidence in chief and then may be cross-examined by opposing counsel and then re-examined. Trials are traditionally held in open courts to preserve public trust in the administration of law, open to the public and media. However, in Canada, the courts now have full discretion to conduct the trial partially or entirely as closed proceedings. Entirely closed, or also known as in-camera proceedings, have become common practice, particularly for sexual assault cases. The Gomeshi case obviously is an exception to that. Very public case. Now in the inquisitorial system, a trial runs a little differently. The prosecutor decides whether the case goes to the trial as a result of the thorough record of the examination phase. The complainant and the victim has a right to request line of questioning and can be represented by their own lawyer. While there is no cross and re-examination of the witnesses are still questioned and challenged. In Germany, there's a preference for narrative testimony, in which the witness gives their version of events without shaping by questions from the prosecution or the defense. Traditionally, there is no ability for the defendant to plead guilty. I would say that in the Canadian system, we generally adhere to the adversarial system. But it does have the mix of the inquisitorial version where the victim has the right to line of questioning. It has that somewhat of an element, not so strong here. And also the narrative testimony. That seems pretty much how we run sexual assault cases, as we've seen with the Jian Gomeshi case. That's my personal opinion anyway. That's open for debate. But for the most part, I would say we follow the adversarial model. The role of the judge and counsel are also different. In the adversarial, the judge is an unbiased and impartial referee at the hearing. It is the judge's function to ensure that the court case is conducted in a manner that observes due process. The judge decides whether the defendant is guilty beyond reasonable doubt, except in jury trials where the jury performs that role, and then the judge determines the sentence. Both lawyers are primarily responsible for introducing evidence and questioning the witnesses. Now in the inquisitorial, judges are required to direct the courtroom debate and to come to a final decision. The judge and the prosecutor are active in the questioning of witnesses, experts, and the calling of evidence in the pursuit of truth. The defense attorney has more of a passive role to ensure legalities of admitted evidence are observed. It is thought that allowing evidence to be brought by both sides would lead to contradiction in evidence, and it would urge witnesses to lie. However, it is now accepted in some inquisitorial systems that the defense should have the right to confront each witness during at least one stage in the proceedings. So here we can see how some of the adversarial system has crept into the inquisitorial system that some countries use. I would say, as far as which one adheres to the most, I would definitely go on the side of adversarial on this one for the role of the judge and counsel. Juries in the two different systems are different. Okay, in the adversarial system, juries are used in many cases In Canada, anyone charged with a criminal offense for which there can be a prison sentence of 5 years or more has the right to choose a trial by jury. In some cases, a person charged with a criminal offense for which there can be a prison sentence of less than 5 years may have the right to choose a trial by jury. Some civil cases can also be tried by judge and jury. After both sides have called all their witnesses and presented their arguments, the judge instructs the jury on the law and on what they must take into account when making their decision. Their decision must be unanimous. In the inquisitorial system, juries are generally only used for the most serious cases. Their decision does not have to be unanimous. It can be a majority decision. Now, the interesting thing here is in Canada, the general assumption with the adversarial system is that juries are used most often than not. However, in Canada, we tend to not use juries in cases of sexual assault. Where that discrepancy is that a lot of defendants are talked out of a jury for various reasons. I know in my husband's case, he wanted a jury. He wanted a jury for his trial. He was absolutely insistent on having a jury. And at some point, by his own lawyer, got talked out of it. Now, we don't know if his case would have turned out differently if he had used a jury or not. But my point here is that most of these cases are tried by judge only. And the more of these cases we get, we cannot no longer say that juries are used in many cases. We start to lean more towards the inquisitorial system where juries are only used for the most serious cases and or the most public cases. In the Gomeshi case, there was no jury. The use of juries in either system, I don't know, that's a very debatable topic within itself just because of the media involvement and the way propaganda tends to shape the general public's thinking about things. So, there's a lot that can be discussed in the use of juries, regardless. The rules of evidence. In the adversarial system, the rules of evidence and procedure are strict. Evidence which is prejudicial or of little probative value is more likely to be withheld from juries who don't have training on the weight that should be given to certain evidence. However, hearsay evidence is more readily allowable if it is reliable. Only certain types of evidence are admissible and others are inadmissible. Rules can be created by different systems to protect witnesses from harassment or undue embarrassment and to treat all parties fairly. Now, inquisitorial, the rules around admissibility of evidence are significantly more lenient. The absence of juries in many cases alleviates the need for many formal rules of evidence. More evidence is likely to be admitted, regardless of its reliability or prejudicial effect. Evidence is admitted if the judge decides it is relevant. In many inquisitorial systems, there is no hearsay rule, for example, France, Belgium, and Germany. It is up to the judge to decide the value of such testimony. Now, in Canada, we are definitely more like the inquisitorial system because particularly at the superior court level, where serious crimes are tried without a jury, and again, in sex assault cases, for example. Now, we do have a lot of rules for the types of evidence that can be admitted against a witness or against a complainant or victim, whichever word you prefer. When it comes to rules of evidence that can be admitted against the defendant, they go out the window. We actually have it stated in one of our codes, Evidence Act or somewhere, that the judge can admit any evidence if they decide it's relevant, and that fits the inquisitorial model. So again, here we have more of an inquisitorial system when it comes to the rules of evidence. The rights of the defendant. Here we have something where it's pretty much exactly the same. In both the adversarial and inquisitorial system, the accused is protected from self-incrimination and guaranteed the right to a fair trial. However, in the inquisitorial system, it is generally interpreted as a sign of guilt for the defendant to remain silent throughout their proceedings. With the role of the complainant or the victim in the adversarial system, complainants or victims are not a party to proceedings, and prosecutors act on behalf of the state and do not represent the complainant/victim. In the inquisitorial system, the victim generally has a more recognized role in inquisitorial systems. They usually have the status of a party to proceedings. In some jurisdictions, victims have a formal role in the pretrial investigative stage, including a recognized right to request particular lines of inquiry or to participate in interviews by the investigating authority. At the trial, they generally have independent standing, and some jurisdictions allow victims to be represented by their own lawyer. Now, we don't specifically state that as a hallmark of the adversarial system. We just state that the complainants or the victims are not represented by the state, period. So, having seen what's happened in the Ghomeshi case, we know that all three witnesses, women in that case, they all had their own lawyer, and two of them had the same lawyer. Now, this is worthy for debate again, because should witnesses have their own lawyers coaching them throughout the process? And the next question would be, should these lawyers have contact with the Crown as well as the defense? Should those lines of communication be strong leading up to the trial? That is up for debate. A lot of victims' rights advocates want the victim to have a formal role in the proceedings. They fight for that, and as they have fought for it over the years, they have been given those rights. So they have the right to their own lawyer, and their own lawyer can do their communications for them. And they also have their own right to a court support worker who is supplied by the state. And they get a lot of rights. They are treated like a formal party to the trial, to the case. The victims' rights advocates would also like to see it so that if they do need a lawyer, either in a criminal prosecution or a civil case, which is a monetary lawsuit, that the state would provide them with their own lawyer at the cost of the public purse. This is the next level that victims' rights advocates would like to take it to. And we are therefore creeping completely towards the inquisitorial model in that respect. Next is a binding force of case law and precedents. Here's a major difference here. Adversarial. Previous decisions by higher courts are binding on lower courts. Inquisitorial. Traditionally, there is little use of judicial precedent. This means judges are free to decide each case independently of previous decisions by applying the relevant statutes. There is therefore heavier reliance on comprehensive statutes and codes of law. So as we can see, it appears that in both systems, case law and precedents exist, which makes sense because every time a case is ruled, it may set a new precedent. And basically what that means is it's a reinterpretation or a new interpretation or a more thorough and detailed interpretation of a provision that exists in the statute or the code of law. So here in Canada, we assume that all decisions are binding. All higher court decisions are binding on lower courts. So basically we make decisions purely based on previous case law. And it's confusing because we do have a criminal code, which is the hallmark of the inquisitorial system. Civil codes, statute code, codes generally, where provisions are stated, what the crime is, and what the definition of that crime is. So it gets confusing because obviously we need some sort of code book that tells us what our crimes are. and what crimes, what constitutes the criteria to meet that crime legally. And it also is what the prosecutors, under the adversarial system, it is their burden to prove the case. It is their burden to prove that the crime happened. So they have to rely on that code to determine what the criteria is for that crime and prove to the judge and the jury that all of the criteria that fall within that code were met, and therefore the judge must find a conviction. So where it gets confusing is where you mix in case law from previous cases. Even though the codes may be the same, the interpretation can be different, and no one case is the same as the next case. So one case was interpreted and it set a precedent. So even though the codes might be the same, they interpreted something new or different about that code relevant to that type of case. And so moving forward, when a judge is evaluating a verdict on a case, they have to look at case law, and they have to apply previous cases to support their decision. Now, there's a lot of controversy about precedents in case law because ultimately it depends on the judge. It depends on the judge hearing the case. If they want to convict in a case where there's no evidence, they can go digging through the case law to find cases that will support that conviction because they exist. Over time, you have so many different judges with biases. Even though they're not supposed to be, they're supposed to be impartial. Not all of them are. So the partial ones will make a case. They will make a verdict, and they will create new precedents, and Supreme Courts do the same thing. They reinterpret things. So it becomes a problem because now you've got a situation where basically there's just so much case law built up that you can find a case law from the past to justify any decision, whether it's the correct and fair decision or not. So the advantage to the inquisitorial system is that those precedents and those previous case laws are not binding. So they don't have to rely on previous cases. They don't have to spend all the time digging through case books and reading and this and that. They first and foremost will look at the code and ask the questions and analyze thoughtfully and thoroughly if all of the evidence provided actually proved that these crimes happened. The thing with the Canadian legal system is that, again, it depends on the court. The superior court tends to rely on case law more often than not. The lower courts generally rely on codes. They analyze the codes and they determine if the Crown, beyond a reasonable doubt, proved their case, proved that these crimes happened the way the code defines the crimes exist, what their definition is. I hope you're following me here. I will probably make another follow-up video on this. Anyway, to sum this up, the Canadian system is a mix of the adversarial and the inquisitorial system. We do a combination of the two, depending on the judge and depending on the level of court the trial is being heard. We will either completely adhere to precedents and previous case law, and primarily, and then statutes secondary. But there are other judges and other levels, lower levels of court, where they will primarily rule based on statutes and code. So it's very confusing. The next hallmark of adversarial versus inquisitorial is the organization and jurisdiction of the courts. I've already been talking about this. In the adversarial system, generally, they have courts of general jurisdiction available to adjudicate a wide range of cases. In the inquisitorial system, civil law systems tend to have specialist courts, and specialist appeal courts to deal with constitutional law, criminal law, administrative law, commercial law, civil law, private law, etc. Now, here is pretty much where it becomes very clear that in Canada, the hallmark of our legal system in this respect leans towards the inquisitorial system, because we have special courts. We have multiple levels of courts. And we have tax court, administrative law court, civil court, criminal court, family law court, divorce court, domestic violence courts, women's court, where they hear constitutional cases just for women. And we have, I don't even know how many courts we have, but we have multiple courts, and they are not all under the same jurisdictions. Again, we have the magistrate level, we have the provincial level, and we have the superior level, and we also have the supreme level. And people are pushing for special courts just for sexual assault now. I'm sure this is not news to you. Having the Ghomeshi case being as public as it is, a lot of people have recognized that there are people who want special courts for sexual assault. The funny thing is, we essentially already do have special courts for sexual assault. The only thing that doesn't make that concrete is that our judges the judges we have may hear a sexual assault case, may also go and hear a civil law case between two companies. So completely different areas of law right there. However, if we do create separate courts just for sexual assault, that would definitely constitute a specialist court. And right now, with all the rules that we have that are different for sexual assault, one can argue we already have special courts for sexual assault. So in conclusion, I put together this matrix based on my analysis of all the different phases of our legal system, where we fall on the comparison of adversarial versus inquisitorial legal system. I hope other people take everything that I've discussed in this video and actually focus on different areas of this that concern them or that they are curious about, because it's a lot to take in. It's a lot to research. I myself spent 2 or 3 days researching just to get this amount of information. So nonetheless, I think this matrix sums it up nicely. The conclusion to all of this is that, contrary to what we assume, our justice system is not 100% adversarial. Rather, a perverted mix of adversarial and inquisitorial. It seems that some of the more flawed functions of each system have melded together, creating a system which cannot be labeled as one type of system versus another. Both systems have functions that are susceptible to corruption and unfair treatment of the accused on some level, with some of the more negative aspects of the inquisitorial system adjacent to the more negative aspects of Canada's adversarial system. It appears to have eroded the presumption of innocence, along with safeguards protecting one's innocence throughout the criminal proceedings. Additionally, the overreaching powers of the prosecutor appear to have surpassed what the adversarial system was designed to prevent.